Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today what I'm going to talk about is going to binding arbitration in a divorce or post-judgment family law case. Now, normally the goal in any case is to try to resolve the dispute via settlement, where, parties obviously have different positions going into a case, and the whole court process is set up to help people reach an agreement. Now, ultimately, if you are unable to reach an agreement for whatever reason, the final step is to have a trial where you go in front of a judge and the judge makes a decision. Now, in certain circumstances, you may want to avoid having a trial with a judge to resolve a dispute, and you may instead want to go to binding arbitration. And that's essentially where you're still going to a neutral third party, but it is outside of the public superior court, and it's in a more private setting in front of usually a retired judge. But an arbitrator is usually going to be a retired judge or an experienced attorney who's familiar with cases in whatever area of law you are arbitrating in. In this case, an experienced, usually former family court judge. So the reasons you might want to go to binding arbitration are, again, you want it to be a more private setting where you're not in open court where there's a transcript of all of the proceedings. You may also want to go to binding arbitration so that you can control your own schedule. As I make this video now, towards the end of 2022, the courts are very backed up. Some of the courthouses, if you want to get a trial, you're looking at having a trial date a year from now. Well, if you agree with the opposing party to go to binding arbitration, you can have your arbitration take place much sooner, a month or two, depending on the availability of whoever is doing the arbitration. Another reason is you don't like the judge that you're assigned to. Some judges are wild cards, and they may not be experienced, or they make crazy decisions. And if both parties are on the same side of saying, I don't really want to have a trial in front of this judge, it's unpredictable and he could screw over either one of us, that may be a reason to go to binding arbitration. Or sometimes the judges are just inexperienced. It might be a newly assigned judge who's not familiar with family law. You may say, all right, I don't really want to have a trial with an inexperienced person. I'd rather go to binding arbitration and be able to control the environment where we are with a, usually former judge who has a lot of experience in family law and is going to make a reasonable decision, and ultimately a fair decision, which is usually what people want to try to get to. So if you do decide you want to go to binding arbitration, you have to file certain documents with the court. So I'm going to go over those very briefly. So the statute that regulates arbitration is 52-408. I'm not going to get into the details of that now. If you want to look over the statute, I would suggest you do so. But if you're agreeing to go to binding arbitration, you need an arbitration agreement. So I will have a sample of this video on our website under the videos section. So if you want to go on our website, you can basically copy and paste this. Obviously you'll have to change the heading of the case. And in this, I have the arbitrator being Linda Monroe, who's a very experienced retired judge here in Connecticut. But you'll have to update the names of the parties and who the actual mediator is. You'll have to list, what issues are in dispute, etc. So you're going to want to file this with the court and have it, entered as an order of the court. And what you're also going to want to do is have an affidavit regarding arbitration where the party to the case. So if you're watching this and you're an attorney, your client's going to want to do this affidavit that basically says that you've had an opportunity to review the arbitration agreement. You think it's, you've been advised of the pros and cons of going to arbitration. You think it's fair and equitable for you and your spouse or former spouse to go to arbitration, etc. Now, the one catch with arbitration? Well, the biggest catch with arbitration is that you can't appeal an arbitration decision. So normally, if you have a trial in front of a judge and the judge makes a decision and it's a crazy decision, or it's a decision that's unlawful for whatever reason, there are certain circumstances in which an appeal might, you can file an appeal in any circumstance, but the appeal may overturn that decision, in which case, if it is overturned, you can go back to a new judge and have a new trial, basically. So that is your remedy if you don't like the decision of the judge after a trial. But if you have an arbitration and you don't like the arbitrator's decisions, your hands are pretty much tied, where you cannot appeal that decision. So once those documents are filed with the court and the court approves the arbitration agreement, you're free to go forward with your arbitration. So those are the basics of how to get into arbitration. I will create a separate video that talks about what you do after you have a decision from the arbitration. So I will create that separate video down the road. Now, again, if you want to have copies of the arbitration agreement, the sample arbitration agreement, or the accompanying affidavit, feel free to visit our website at dolanfamilylaw.com. Have a good day, and if you have any other questions, feel free to contact our office at any time, as usual. Take care.